Hello, I'm Lau Yuk Lian. Now this is my turn to present the PPT. In my part, I will focus on the related topics and laws connected to this case. We are looking at three main topics: the significance of formal letters and notices, the importance of procedural fairness, and the burden of proof of dismissal disputed. Alongside this, I will also explain the main law that apply, which are the Employment Act 1955, the Industrial Relations Act 1967, and the Industrial Court Rules of 1967. These issues are very important because they decided whether a termination is lawful or unlawful. If an employer ignores procedure or fails to follow the law, it can weaken their case in front of the industrial court. So let us look at each part more closely. One of these first topic in this case is the absence of proper formal letter and notices. Under employment law, an employer cannot just dismiss or punish a worker verbally. All disciplinary action, suspension or termination must be put in writing. This ensures transparency, it gives the employee the opportunity to respond, and it protects fairness in the workplace. In this case, the employer failed to follow this basic step. For example, Mr. Andy only told the claimant verbally not to report to work on 15 January 2023. No written termination letter was given. Later, the company only responded after the claimant's lawyer sent a demand letter, which shows poor communication. And finally, when the company accused the employee of abandoning work, no warning letter was issued. All these missing documents clearly weakens the employer's legal standing. Without written evidence, the company cannot prove that it acted fairly or according to law. The second topic is procedural fairness. This principle means that every employee must be given a fair chance to be heard before any action is taken. An employer should not rush into termination. Instead, the correct steps are issue a show cause letter, give the employee the opportunity to explain, and if necessary, suspend the worker while conducting an inquiry. If an employer ignores these steps, it becomes a violation of natural justice. Natural justice is the idea that decisions must be made fairly, without bias, and with respect for the rights of both parties. In this case, because the company dismisses the worker without giving him this opportunity, it shows that procedural fairness was not followed. This makes the termination unlawful. The third topic is the burden of proof. In dismissal cases, the law is very clear about who must prove what. First, the employee must prove that a dismissal actually took place. Once that is shown, the responsibility shifts to the employer. The employer must then prove that the dismissal was justified and based on just cause or excuse. This means the employer must provide documentary evidence such as letters, notices, or proper records, as well as reliable witness testimony. If the employer only makes verbal claims or relies on unsubstantiated accusations, it will not be enough. In this case, because the company did not have the proper documents or procedure, it becomes very difficult or then to prove that the dismissal was lawful. Now let us look at the first law, the Employment Act 1955. This law covers important rules about termination of employment. Section 12 requires proper notices period. The notice length depends on how long the employee was worked. 4 weeks if less than 2 years, 6 weeks if between 2 and 5 years, and 8 weeks is more than 5 years. Section 13 allows termination without notices, and only if the other party is compensated with indemnity. Section 14 says that if there is misconduct, the employer can only dismiss after a proper domestic inquiry. is held. Section 14 also allows suspension, but only up to 2 weeks and with, uh, with at least half salary pay. Section 15 states that if an employee is absent for more than 2 days without permission or a valid reason, it may be considered a breach of contract. So the action is clear termination cannot be done suddenly or unfairly. Procedures and notice period must be followed. Finally, let us consider the Industrial Relations Act 1967 and the Industrial Court Rules of 1967. Section 20 of the Industrial Relations Act allows any employee who believes they were dismissed without just cause or excuse to file a representation with the Director General. If the matter cannot be solved, it will be referred to the Industrial Court. The court has the power to order reinstatement or compensation. Importantly, Section 30 tells the court to act according to equity, good conscience, and the substantial merit of the case, not just strict technicalities. This means the court look at the fairness and justice, not only paperwork. The Industrial Court Rules of 1967 set out how cases are managed. They make sure both parties have equal chances to present documents, give evidence, and make argument. These rules to help maintain justice by ensuring that cases are handled in an organized and fair way. So in this case, this law and rules together provide strong protection for employees who face unfair dismissal. They remind employers that any action must be transparent, justified, and in line with proper legal procedure. In conclusion, we see that the absence of formal letters, the violation of procedural fairness, and the failure to meet the burden of proof all point to weaknesses in an employer's case. The Employment Act 1955, the Industrial Relations Act 1967, and the Industrial Court Rules of 1967 set very clear standards for fairness, transparency, and due process. Employers who fail to follow these rules will face legal consequences. That's all for my presentation. Now I will pass the presentation to Mr. Haika. Thank you.